So there were two referendums obviously being held on the 8th of March. One is they're referring to it as the Family Referendum, and the second one they're referring to it as the Care Referendum. So the first one they're going to look at is the Family Referendum. So can everybody see that? Yeah. So the areas of discussion will be a brief overview of the Family Referendum, the current wording of the Constitution, proposed amendments to the Constitution, why the government say the Constitution needs to be amended, what type of relationships could other durable relationships include, are the proposed changes to the Constitution necessary to enable the government to offer the same rights and protections to those who are not married, and potential consequences of a yes vote. So just to say that in terms of areas 1 to 6, all of that information will be factual. It'll be taken from Dáil debates. It'll be information that's been given out by TDs and senators. It'll be taken from the Constitution. It'll be taken from case law. The only part that is conjecture or my opinion is part 7. So a brief overview. So on the 5th of December 2023, the general scheme of the proposed 39th Amendment of the Constitution was published. So a general scheme is a draft bill. So before something becomes a bill, the government publish what's called a general scheme. So it's just the heads of the bill, really. So that was on the 5th of December. On the 6th of December, Roderick O'Gorman TD sought and was granted a waiver from pre-legislative scrutiny. So we'll talk about what that is in a minute, pre-legislative scrutiny. On the 7th of December, the government approved the publication of the proposed amendment to the Constitution. And on the 8th of December, it was actually published. So that happened literally in the space of 3 days without any scrutiny from TDs or senators before it was published. And as of the 20th of February today, the 39th Amendment of the Constitution is currently at the 3rd stage in the Seanad, having completed 8 out of 11 stages in a matter of weeks and having completely bypassed the pre-legislative scrutiny stage. And it's all in a bid to make sure that the vote takes place on International Women's Day. So you can see on the screen here, I've just set out, so this is an extract from the Bills and Acts section of oireachtas.ie website, which is the government website. And you can see here that it started in the first stage in the Dáil on the 8th of December. And by the 17th of January, it had gone through all the stages in the Dáil, but that's taking into account the fact that they were shut down for a month. Then it went from the Seanad first stage to the 3rd stage between the 17th and the 23rd of January. So that's how quickly an amendment to the Constitution has gone through the Dáil and the Seanad. So the explanatory memorandum to the bill states that the purpose of the bill is to propose to add text to Article 41.11 of the Constitution, which acknowledges that the family may be founded on marriage or other durable relationships. The bill also proposes the deletion of the words on which the family is founded. So we'll look at a minute at the exact wording in the Constitution and how they're proposing to amend it. And Roderick O'Gorman TD, who is the minister that's proposing these amendments, has said that the present wording of Article 41.11 does not reflect the values of the country and means the exclusion of thousands of families from the recognition and the protection of the Constitution solely because those families aren't based on marriage. So it's really important to recognise what he's saying. He's saying two things. First of all, thousands of families are not recognised or protected by the Constitution because they're not families that are based on marriage. So in short, the purpose of the proposed amendment to the Constitution is to extend the definition of family, which is currently based on marriage in the wording in the Constitution, to also include other durable relationships. So I just want to speak just for a couple of minutes on just pre-legislative scrutiny, because it's really important to realise that they bypassed this. It's really important to realise why this was brought in. So pre-legislative scrutiny is a process by which the Dáil and the Seanad scrutinise draft bills, in this case meaning the general scheme of the bill, and report back with observations or recommendations to the minister sponsoring the bill. Pre-legislative scrutiny was first introduced into the Houses of the Oireachtas following the 2011 general election as part of negotiations between the then coalition partners following calls for parliamentary reform in light of the economic and banking crisis. So what they were saying was all of this stuff was happening in the country, I suppose 2008, 2009, 2010, and they were saying that there wasn't enough parliamentary oversight and scrutiny of legislation by TDs and senators before it became a bill. And they said, these people are elected into these positions. We have 160 TDs in the Dáil. All 160 TDs should have some involvement in the legislative process before a piece of legislation becomes a bill. So the requirement for pre-legislative scrutiny was formally adopted into Dáil and Seanad standing orders as a requirement for the government bills, save in exceptional circumstances. So what they were saying was that in 2013, as part of the coalition between different government parties to come together to form a government, they said that we want to be sure that all TDs are involved in the legislative process. So they actually put it into the standing orders. So that's the rules that govern the Dáil and the Seanad. They put it into the standing orders, and they said that every bill has to go through pre-legislative scrutiny except in exceptional circumstances. So that was in 2013, and that reform was carried through to the 2016 and the 32nd Dáil in 2016. And this reform was considered necessary due to the perceived weakness of the Houses of the Oireachtas in terms of executive oversight and political and institutional capacity to influence the government's legislative agenda. So when we talk about the government, a lot of the time people think when we're talking about the government, we're talking about all of the TDs. That's not actually what it means. That's not what the Constitution tells you the government means. So when we talk about the government, we mean the cabinet, which is made up of senior ministers responsible for the executive power of the state. And it's Article 28 of the Constitution that tells you exactly who the cabinet is, and that means who the government is. So the Constitution tells you that the cabinet is made up of no less than 7 and no more than 15 members. So it's the Taoiseach, the Taoiseach, and up to 13 other ministers. So when they refer to the government, that's who they're referring to. So the fear was that the government, meaning a maximum of 15 people, were effectively running the country. That was the fear, and that's why they brought in pre-legislative scrutiny. As a means of responding to this lack of oversight, it was agreed to introduce pre-legislative scrutiny as a mechanism by which the Dáil, meaning all TDs, could have meaningful involvement in the drafting of proposed legislation before it became a bill, thereby giving them real and substantive influence in the lawmaking process. And the 2016 programme for government stated, we will support mandatory pre-legislative scrutiny for all new bills and post-enactment review of legislation. So you can see the standing orders there where they actually included it in the standing orders, and it's save in exceptional circumstances, pre-legislative scrutiny will happen. When the 32nd Government of Ireland took office in June 2020, so we're obviously talking COVID has happened, there's a lot of laws being passed very, very quickly, there's a lot of regulations being passed, and the one thing that I would say about COVID is a number of TDs actually brought a regulation, or actually brought, a bill before the government around this area of pre-legislative scrutiny around regulations. So what they were saying was the government were bringing in so many regulations around COVID at such a rapid speed without any oversight from any of the TDs apart from the government, who are the cabinet, these up to 15 people. And they were saying they weren't happy with the way that it was being done, and they actually tried to bring in a piece of law to make sure that the government would have to discuss any of those regulations with them. It never went anywhere, but it just shows you there was a reason behind why they didn't follow through with the pre-legislative scrutiny in 2020. So in 2016, so 2013, 2014, 2015, 2016, they had pre-legislative scrutiny. They couldn't waive it except in exceptional circumstances, but they changed it in 2020. So they said to permit a waiver in accordance with any guidelines agreed by the committee. So what they said was, we don't really want to do this pre-legislative scrutiny thing. You know, we basically want to be able to run the country as 15 people. And it wasn't possible. You know, they're the government. They obviously they were able to bring in whatever standing orders they deemed necessary. As stated earlier, in the case of the proposed 39th Amendment, Roderick O'Gorman-Sullivan was granted a waiver from pre-legislative scrutiny. Several TDs and senators raised this as a major area of concern when the bill was going through both the Dáil and the Seanad. And this is a quote from Senator Ronan Mullen, where he said, "The lack of respect for our Oireachtas process on show here, with it going through 3 stages in the Dáil in one day and 4 stages to be got through this week, is an absolute disgrace. When one considers the way the Constitution is amended, it is a compact between the people who have the final say and the legislators who decide what is to be put in front of them. What is going on with many issues these days is massive insiderism. It is not the entire government, but a cohortee within the government, certain NGOs and certain people on the inside, who get to decide what the people must think, and there is to be minimum discussion, analysis, scrutiny, criticism, and amendment of that by the directly or indirectly elected representatives of the people. Here the government shows its absolute disrespect for the people of Ireland in going about these referendums in the way that it is." So it's not just that they don't want the people to be involved in legislation before it becomes a bill. They don't actually want TDs or senators to be involved in it either. And this is another quote then from Michael McDowell, so Senator Michael McDowell, who was a former Taoiseach and former Attorney General. So he said, firstly, I have to totally endorse what Senator Mullen has said about the guillotining of this bill. It is disgraceful that it is being shoehorned through in the manner that it is. What was the hurry? I will tell the House what the hurry was. Some idiot in government buildings said there will be a better chance of getting this through if we say it's going to be held on International Women's Day, the 8th of March. That is what happened. We got stuck with the ridiculous notion that this will help the bill to go through, and we will be seen to be pro-woman and doing something on International Women's Day if we select that day for the vote on a referendum. As I said yesterday, this is a gimmick, but it is a crude little gimmick. It is not the way a constitution should be changed. It is shameful that that stunt was allowed to be a backstop in terms of time for considering change to our constitution. So that's just a taste for a couple of senators who have raised this as an issue. Numerous TDs raised it as an issue. And it is a gimmick. It is a gimmick that the government said we're going to give very, very minimum discussion and debate in both the Dáil and the Seanad because we've decided that we want this to go through on International Women's Day. So section 2, so the current wording of the Constitution. So Article 41 is the article that deals with the family. What it says is the state recognises the family as the natural, primary and fundamental unit group of society and as a moral institution possessing inalienable and imprescriptible rights, antecedent and superior to all positive law. So we'll just touch on in a minute what we mean when we talk about positive law. So positive law is man-made law. So what they're saying is that the family is superior to any man-made law. So the rights that people have, the protections that people have under the Constitution. There isn't a government alive, there isn't a person alive that can write something down on a piece of paper and say, I grant you this right. You have the rights by virtue of being alive. So there needs to be some serious justification for somebody taking away any of those rights. It says, the state therefore guarantees to protect the family in its constitution and authority as the necessary basis of social order and as indispensable to the welfare of the nation and the state. The state pledges itself to guard with special care the institution of marriage on which the family is founded and to protect it against attack. So on the next slide here, So this is an extract from this document that was published by the Institute of Public Administration. So it's a review of the Constitution between 1937 and 87. And this is a quote or an extract from a Supreme Court judge, Brian Walsh, in relation to some of the articles in the Constitution. So he said, the rights set out in Article 41 to 44, inclusive of the Constitution of Ireland, are the ones that are most noticeably influenced by natural law considerations. The Constitution does not claim to confer or bestow any of the rights set out there, but rather expressly acknowledges them as having existence outside the law and beyond the law. So it's really important to note that when the government is talking about bringing in laws or restricting freedoms, they like you to think that they've granted you these rights, that they've granted you these freedoms. You have these freedoms and these rights by virtue of being alive, so there needs to be some serious justification any time they try to restrict them. So the next section here is, you can see on the top of the screen there where it says whether founded on marriage or other durable relationships. So that's the part that they want to add in. And you can see down here where it says on which the family is founded, that's what they want to delete. So that's the entirety of the amendments that they want to make for this amendment or this referendum on the family. So the state recognises the family, and what they want to add in is whether founded on marriage or other durable relationships. And then down here, the state pledges itself to guard with special care the institution of marriage and to protect it against attack. So it did say on which the family is founded. So what they really want to do is they want to add in the concept of other durable relationships. So that marriage wouldn't be, or the family wouldn't be just founded on marriage, it would be founded on marriage and other durable relationships. So it's really important to know, to understand what other durable relationships are then. So why the government say the Constitution needs to be amended? They're saying there's 3 reasons. 1, due to societal changes to the meaning of family. 2, to introduce the recommendations from the Citizens' Assembly on gender equality. And 3, to extend the protections offered to the family under the Constitution, which they say are limited to families based on marriage, to include other durable relationships. This is my opinion here now. But in reality, in my opinion, the government are seeking to sever the special ties that exist between marriage and the family under the Constitution, thereby diminishing the importance perceived or otherwise of the institution of marriage. So we're just going to go through a few of the reasons. So obviously I said there that the three reasons: societal changes to the meaning of family, the Citizens' Assembly, and other durable relationships. So we're just going to touch on each of those three just to see why the government have said, or what the government have said these are necessary for. So due to societal changes to the meaning of family. So when the government publish an amendment to the Constitution, they also publish a bill digest. So this is a document that's prepared by the Houses of the Oireachtas, the Library and Research Services of the Houses of the Oireachtas. So this is the actual government document setting out why they want the Constitution to be amended, why they feel it needs to be amended. So you can see on the right-hand side of the screen where they're talking about background, societal changes and the family. And they say a number of issues continue to generate debate. In particular, the constitutional emphasis on the position of the married family is somewhat at odds with the growing number of non-marital families in the country. And then they provide some key statistics from the census in 2022 in respect of households and families. So they say the number of families with no children saw an increase of 11%. The number of same-sex couples increased by 157%. And since 2016, the number of cohabiting couples without children living in private households went up 17%. So that's part of the justification. And they also, this is a further part of the bill digest. So table 1 here is percentage change in family units in private households. So you can see that they're saying that one parent father with children, that the numbers have increased. I think one parent mother with children is slightly down a bit. Cohabiting couples, that might actually be slightly down. But what they're showing you is that the numbers are quite high in those, what they would call alternative family arrangements. You can also see here table 2 then, births outside of marriage. Between 2010 and 2022, they're saying it went from 33% to 43%. So what they're saying is that because there are so many people cohabiting and not marrying, because there are so many people that are having children outside of marriage, and they're saying that those families are not protected or recognised by the Constitution, and they're saying that's the reason that we need to bring in this term, other durable relationships. So the second reason, you can see on the top of the screen, to introduce the recommendations from the Citizens' Assembly. So the first thing to note is that it's a Citizens' Assembly on gender equality. So you might forget then that we're talking about including an amendment to the Constitution where marriage, or where the family isn't just based on marriage, it's also based on other durable relationships. So I don't really understand why the Citizens' Assembly on gender equality would actually be involved in that, because we're talking about what we have in this country now: marriage between men and women, marriage between men and men, and marriages between women and women. So I don't see where the gender inequality is in that this actually came within their remit at all. So there's probably another agenda behind why they actually brought this into the Citizens' Assembly. So there are a number of things that the Citizens' Assembly were actually asked to look at, and this one area that we're talking about now wasn't actually included in it. The Citizens' Assembly also, I think they made something like, I'm not sure, was it 25 recommendations? 45 recommendations were made by the Citizens' Assembly. And it was agreed by the committee to prioritise considerations of proposed changes to Article 40.1 and 41. So they made 45 recommendations on what they said were gender inequality in the country. But what they actually brought forward to the Joint Oireachtas Committee on Gender Equality, what they actually brought forward and what they wanted to implement were these changes that didn't even seem to be part of their remit to begin with. So you'd have to ask, I suppose, what the basis behind that is. So this the Citizens' Assembly on Gender Equality was set up in 2019, and they obviously made recommendations in relation to this wording that we're looking at now. And then the Joint Oireachtas Committee was set up thereafter in order to decide what recommendations from the Citizens' Assembly should be implemented. So these are some of the actual recommendations that the Citizens' Assembly made. So recommendation 2 was Article 41 of the Constitution should be amended so that it would protect private and family life, with protection afforded to the family, not limited to the marital family. And then on the right-hand side, it says there have been calls for many years for the reference to the family in the Irish Constitution to be expanded. It's important to note, though, when these Citizens' Assembly happen, so it's normally 100 people, there's normally one chairperson and 99 citizens that are chosen at random from the electoral register. And and they obviously, their remit is set out by the government, and they go through a number of different meetings in order to decide whether or not recommendations would be put through, and they do different ballot questions on the members of the Citizens' Assembly to decide whether or not something should be proposed to the government or not. So these are some of the questions that were part of the ballot. So on the left here we have draft questions, and these were the final questions. So you can always see the way that these things are worded, that very few people would actually say no with the way that they're worded, but they don't seem to talk about the potential consequences of, if you vote yes to this, what's the next obvious step. So the questions were, do you think the family, however it might be understood, is something that should in principle be recognised in the Constitution and given special constitutional status and protection? Who's going to say no to that? Then, should the Assembly recommend that the constitutional understanding of the marriage be expanded, of the family be expanded to include forms other than the marital family? Again, probably very few people would say no to that. And we look at it shortly whether or not families other than families based on marriage are actually recognised and protected by the Constitution as it stands. Then the final questions were, should the Constitution continue to provide recognition for the family? Who's going to say no to that? Then, should the Constitution protect private and family life, including forms of family life beyond the marital family? So when it came to those questions, 98% of people voted in favour. So the final reason then that they want to bring forward this amendment is to extend the constitutional protection to other durable relationships. So again on the screen, this is the Bill Digest. And what this says is that according to Article 41.31, the guarantees and protections afforded by the provisions are limited in scope to the family based on marriage on which the family is founded. So that's what the Bill Digest is telling you. That's what the government are telling you, that the only family that's protected and recognised by the Constitution is the family based on marriage. And then over on the right-hand side of the screen, the meaning of marriage in a constitutional context was originally informed by a Christian ethos. So it's all church bad as well. And on the right-hand side of the screen here, they're saying, as is illustrated from the case law above, the constitutional concept of the marital family is relevant to several areas of law and statute, including but not limited to taxation, social welfare, succession, guardianship and family law. And then down below, they're saying that they've had to introduce legislation at different points to provide some of the privileges that are granted to married families to non-married families. So there was a piece of legislation they introduced in 2010, the Civil Partnership and Certain Rights and Obligations of Cohabitants Act 2010. So what they were saying was, because there's a difference in treatment between married families and unmarried families, they had to introduce certain legislation. So what they're telling you here is that by virtue of being a married family and the protections that you're granted under the Constitution, there are certain implications for taxation, social welfare, succession and all of that. So this is what Roderick O'Gorman said in the Dáil debate around the need to extend the constitutional protection to other durable relationships. He said, today I am bringing before the Houses two bills, the aim of which is to update our constitution to reflect the values of a modern, inclusive Ireland. Words are important. As the fundamental law of Ireland, the words in our constitution are particularly important. They have real legal meaning. They speak to our values as a country, and right now the words of Article 41 of the Constitution do not match our values. Those words mean the exclusion of thousands of families from the recognition and protection of the Constitution solely because those families are not based on marriage. And down below then he said, the proposed amendment reaffirms the family as the fundamental unit of society. It does this in a way that recognises families beyond those based on marriage, including lone parent families and couples who choose not to marry whether or not they have children. So what he's saying is that what he wants to recognise through the term other durable relationships are lone parents and people who are cohabiting whether or not they have children or not. That's what he's telling you he wants recognised by that term. What other TDs and senators have said though in relation to the term other durable relationships. So these are TDs and senators that are going to vote yes, but this is what they're saying about other durable relationships. So Deputy Sorcha Clark, I'm concerned by some of the language proposed in the amendment. As the Minister stated, words matter. My concern includes a reference to durable relationships. Why was that language chosen? Deputy Rita Cronin, the word durable is strange and weak in this context. It is more suitable to describing a battery. Deputy Rory O'Murca, while we welcome the fact that we are heading in the right direction, my colleagues have identified specific issues, particularly in respect of the word durable. We need to ensure the government, the minister and the opposition get around to dealing with some of the questions. Ivana Bakchik, she said, second, why use this more complex text referring to durable relationships? Why introduce that new phrase when a more straightforward approach, in our view, could have been chosen? Jennifer Carroll McNeil said, on the other constitutional concepts, the first word that jumped out at me was durability, as I suspect it did Deputy Batchik. It is not a constitutional concept that I've ever seen. I questioned what it meant. It is really important that we tease this through now, because it naturally is going to be a question later. What is durability? Is it about commitment or enduring? What's the difference between a durable relationship between adults and an enduring relationship? I could be in a durable, intimate, personal relationship with somebody that lasts 10 or 20 years, and I could have an enduring friendship with somebody that lasts 40 to 50 years. Holly Kearns said, however, to be certain, can the Minister confirm on the record that the definition of family proposed to be inserted into the Constitution and the term durable relationships is being interpreted as including lone parents and single parent families? So this goes on and on and on with different TDs and senators. There's more on that page, but there's just, it's the same thing over again with TDs and senators saying, what does this term actually mean? So Roderick O'Gorman's response to these concerns was, I do not believe we are including the living scenario which Deputy Clerk set out, where 3 people are living together as friends. That is certainly not the policy intention, and I do not think that would be the interpretation. So first of all, I do not believe, I do not think. Then he said, what we are talking about with the term is the relationship between cohabitants and parent-child relationships. The intention is to capture those committed relationships that exist over a period of time between couples and between a parent and children. It is not intended to capture shorter-term fleeting relationships. I think that is right. That's his response to it. I think this is what we're doing. I think that's right. So Deputy Clarkson Cronin raised the issue of the term durable in EU law. They are correct. It is used in the EU Citizenship Directive and has a meaning. It's used in connection with relationships. It's important to say that many words used in EU law have a different meaning. And then Deputy Sorka Clark said, it is a durable relationship with respect. The Library and Research Service highlighted that it was mentioned by the Oireachtas, or that it was not mentioned by the Oireachtas Committee or the Citizens' Assembly. So what she's saying there is that neither the Citizens' Assembly on Gender Equality or the Oireachtas Committee that followed that developed this term durable relationship. So everybody is saying, where did this actually come from? And a couple of the TDs said, well, we know the term durable relationships from EU citizens law, so from immigration law, from reunification rights. So a number of the TDs actually raised that. And what Roderick O'Gorman said was, don't worry about that, guys. He said, there is that term durable in European law, but Irish constitutional law can have a different meaning. So it's curious then, this document here in relation to, so this is the Bill Digest again. The Bill Digest section that deals with the term durable relationships, 3 pages long, all of it referring to EU law, EU immigration law. That's the Bill Digest that was produced by the Houses of the Oireachtas. So they're saying the legal concept durable relationships is to be found in European Union law regarding the rights of EU citizens and their family members to move and reside freely within the EU. So they're telling you, this is where we got the term durable relationships from, or this is where we know this term from. And what Roderick O'Gorman is saying is, listen, don't look over there, guys, look over here. Roderick O'Gorman has repeated time and again that the term other durable relationships will mean that there will be recognition of families beyond those based on marriages, including lone parent families and couples who choose not to marry whether or not they have children. So he has insisted time and again that it will include and only include lone parents, cohabiting couples with children and cohabiting couples without children. But he can't give this commitment because the term other durable relationships is not defined within the Constitution, so it's going to be left up for the courts to decide what it actually means. So this is an extract from the Dáil debate where Deputy Michael McNamara raises the issue of whether or not polygamous marriages could actually be considered other durable relationships. And what he says here is that, as he understands it in EU law at present, when somebody comes into the country and they're granted asylum here, they're entitled to reunification rights to bring their wife and the children of that marriage into the country. But what he's saying is, if that person in their country of origin has 5 wives and 40 children, if a durable relationship is actually recognised here, will they not be able to bring all of those people over? And what Roderick O'Gorman says is, don't worry about that, guys. There's nothing to do with that. There's no way in the world that polygamous marriages are going to be recognised here. But again, polygamous or durable relationships are not defined under the Constitution, so he can't give that guarantee. So then when Roderick O'Gorman is telling you that, I'm telling you what a durable relationship means. It means we're extending the recognition and protection to lone parents and couples with or without children. That's what he's telling you. The Electoral Commission, though, are telling you that if you send a Christmas card together or receive a wedding invite together in joint names, there's a possibility that could be considered a durable relationship. That's how far-fetched this is. That's how undefined it is. So that's the Electoral Commission are actually saying that. And then here, as I said, the Bill Digest sets out, they're telling you here what durable relationships mean in EU law, and the only reference to durable relationships in the Bill Digest is around this citizen immigration reunification rights. I'm not sure if I'll be able to play this, I'll just check. So this is Neil Richmond TD, government TD.
Well, I think for us it's a constitutional change that is long overdue, and it is a recognition that care comes from many different people and comes in many different forms. And yes, that care and taking on that care is extremely onerous for the person who provides that care or that family unit, and it doesn't necessarily have to be a biological family member. And this is when I want to get to the key point of changing what the definition of family is. This is moving to not just modern time vernacular, but it has serious consequences, particularly when we think of immigration law and proving that someone is family member or family reunification. This will allow that to be accommodated as well. So we're keeping up to space with other communities.
Because you're talking about durable relationships.
Absolutely, yeah.
So that's Neil Richmond, and he's actually saying that, he says that this will have an impact on reunification rights. That's actually what he says. And I think that's on the Tonight Show or something that he said that there about a month ago or so. So you have the Bill Digest telling you that durable relationships, the term, comes from EU immigration. You have the Electoral Commission telling you this term is not defined and it could literally mean people getting a Christmas card in joint names. You have Neil Richmond, the TD, telling you that durable relationships could have impacts, or that term being put into the Constitution could have impacts on immigration law. So, as I said again, Roderick O'Gorman said that it will only include lone parents cohabiting couples with or without children. However, TDs and senators and the Electoral Commission have raised concerns that other durable relationships may include friends living together who are not in an intimate relationship. That was Jennifer Carroll McNeil, TD, that said that. Couples, which does not necessarily people in an intimate relationship who are invited to weddings together or send Christmas cards together. That was the Electoral Commission. Polygamous marriages, that was Michael McNamara, TD. Foster children in relation to contesting a foster parent's will, that was Senator Sharon Keoghan. She asked the question, she said that she had fostered about 100 children. She said at some point in the future, could one of those children come back and contest a will for children that I've given birth to? It's a valid question to ask. She also said, could people engaged in extramarital affairs contest the will of married people? And then finally, then family and friends and extended family and friends of asylum seekers. So these are the TDs and senators that raised that as a concern. Michael Collins TD, Neil Richmond TD, Senator Sharon Keoghan, Senator Michael McDougall and Senator Ronan Mullen. They all raised it as a potential issue around immigration. So the next section is, are the proposed changes to the Constitution necessary to enable the government to offer the same rights and protections to those who are not married? So that was one of the claims that were made, that the recognition and the protection in the Constitution is limited to those families based on marriage. So this again is the Constitution of Ireland, a review of it by the Institute of Public Administration, and this is the section again from Brian Walsh, the Supreme Court judge. So he stated that families other than those based on marriages are recognised and protected by the Constitution as it stands. So he said, it is true that the family envisaged in this article is the family based on marriage, as is made quite clear from the provisions of the article itself. However, it is not correct to say, as it has been frequently stated, that the effect of judicial decisions has been to declare that the only family recognised by the Constitution or protected by the Constitution is the family based on marriage. what the decisions have said is that the family referred to in Article 41 and 42 is the one based on marriage. The courts have said that other articles in the Constitution may be availed of and invoked by what has been called natural families. So that's a Supreme Court judge is telling you that. Second of all, the same question again, are the proposed changes to the Constitution necessary to enable the government to offer the same rights and protections to those who are not married? So do they need to amend the Constitution to make sure that other people can have those rights and protections? So no, we know that it's open to the government to propose any law it wishes to close any difference in treatment that might exist between married and unmarried people. So they even tell you that here in the Bill Digest, that in the past they have introduced legislation to close gaps for cohabiting couples. So they have the executive power as the government to introduce any law they wish, and obviously if they can get it through the Dáil and the Seanad, it becomes law. So if there is a difference in treatment between married people and unmarried people, the government has the executive power to change that. So they don't need to amend the Constitution in order to do that. And thirdly, again, same question again, do they need to bring this amendment into the Constitution to offer the same rights and protections to those who are not married? So again, no, a third no. So the recent Supreme Court judgment in John O'Meara versus the Minister for Social Protection and the Attorney General. So on the 22nd of January, literally in the last 3 weeks, a court case went before the Supreme Court where a widower with 3 children had been looking for a widower's pension, and he was denied it through social welfare. And he challenged it to the High Court, saying that it was unconstitutional that he was denied it simply on the basis that he wasn't married. He lost in the High Court and he won in the Supreme Court. That's literally on the 22nd of January. The Supreme Court said that he couldn't be denied the pension, a widower's pension, simply by virtue of not being married. Okay, so the claims that have been made, number one, is that the Constitution needs to be amended due to societal changes to the meaning of family. Because the Constitution only protects and recognises the marital family. We've already said that the Supreme Court Judge Brian Walsh has stated that families other than those based on marriage are recognised and protected by the Constitution, so that claim is not correct. Number two, they say the Constitution needs to be amended to enable the government to offer the same rights and protections to those who are not married compared to those who are married. We know that that's not correct either, because the government has the executive power to introduce any law it wishes. So if there is a gap between married people and unmarried people, they can introduce a law to change that legislation. And we also know that in the Supreme Court case on the 22nd of January, the John O'Meara case, that it was deemed unconstitutional to deny him a widower's pension simply on the basis that he was not married. The third thing they say is that the Constitution needs to be amended to introduce the recommendations from the Citizens' Assembly on gender equality. That's not correct either. The Citizens' Assembly didn't come up with this term durable relationships. You did see the questions that the Citizens' Assembly were asked, and I would think many people in the room would probably have said yes to a lot of those questions too, but there was no follow-on in terms of what is the consequence if you do this. So they didn't come up with that term durable relationships, and neither did the Joint Oireachtas Committee that followed that Citizens' Assembly. They didn't come up with that term either. And the final thing that they state is that the Constitution needs to be amended to offer so that the protections offered to the family under the Constitution, which they say are based on marriage, to include other durable relationships, to ensure that those other relationships like lone parents and people who are cohabitees who have children or who don't have children, and that they would actually be protected by the Constitution. But the problem is that the term durable relationships, they haven't defined it. It's not limited in scope. Nobody actually knows what the term will include. So what it will actually mean is that the people that they say they're trying to protect and recognise, lone parents and cohabitees, they will more than likely have to go to the courts and argue before the courts that they are a durable relationship. So what they're saying they're trying to achieve won't even be achieved through what they're introducing, because the term is undefined. And as we said together, a number of TDs and senators have raised very, very serious concerns that the term could have serious consequences, particularly around immigration. So the question that arises is, if it has already been determined that the family other than those based on marriage are recognised and protected by the Constitution. So when I talked about that Supreme Court judge, so Brian Walsh was a judge of the High Court from 59 to 61, Supreme Court from 61 to 90, and the European Court of Human Rights from 80 to 98. He's not a, you know what I mean, I was in the Supreme Court there for a couple of years. This is a really well-established, well-respected judge who was saying this. Second point is that the government already has the ability to introduce laws which would enable it to offer the same rights and protections to married couples as unmarried couples as married couples currently enjoy, where protections differ. And considering the Supreme Court judgment as recently as the 22nd of January in the O'Mahony case, where it was held that to provide a social welfare benefit to a surviving spouse of a marriage and not to a surviving cohabitee, that it was unconstitutional. You would have to ask what the real agenda is behind the push to introduce this referendum. So this is my take on why they're trying to introduce it. So I have three potential reasons that I think. Number one is to sever the special relationship that exists between marriage and family. And many of you probably know I'm in a durable relationship with that guy down the back there. So I have nothing to gain. Like, as far as they're concerned, what they're saying is they want to protect the likes of me. I've chosen not to be married. If I wanted to be married, what I know is that there's a very clear line in the sand. I've created, a contractual and, depending on, what your views are, other types of commitments, and that it's from this date forward, this means X. And people like me have chosen for a particular reason not to enter into that type of commitment, like, in fairness, do you know what I mean? Would you like? But anyways, but what they're saying is that this is all designed to protect people like me. I don't know for the likes of us what the tax consequences, what the social welfare consequences, all of those things, but there are potential unintended or maybe intended consequences that they're saying this is all designed to protect people like us. People know when they get married the legal consequences of that, and you're entitled to know the legal consequences that from this date forward, this is how we're going to be treated in law. But they're creating a serious amount of uncertainty. And I believe the reason for that is they want to sever the special relationship that exists between marriage and the family. And the reason for that is, in my view, in our view, it all goes back to Marxism. So I just wanted just one or two really quick slides just on Marxism to understand what we believe the basis behind it is. So 176 years ago, Karl Marx drafted an infamous document called the Communist Manifesto, which was an attempt to solve the problem of oppression in society. That's what Marxists believe, that there's oppression everywhere, that a man oppresses his wife or his girlfriend or whatever, that parents oppress their children, that employers oppress their workers, that there's oppression everywhere, that white people oppress black people, that
we get it, yeah.
So what they try to do is they're saying that they want to solve the idea of oppression in society, but the way that they attempt to solve it is by creating more oppression. So Marx developed a theory that divided society into classes, with those who owned property being the oppressors and those without property being the oppressed. As far as Marx was concerned, wealth was accumulated through the exploitation of the working class, and his theory therefore sought to dismantle the class structure through the abolition of property. So an awful lot of this comes back to abolishing the family, abolishing private property rights. Marx believed that if a benevolent dictating authority, because we know how, they're everywhere, forcefully took ownership of all the wealth, property and resources, that it could be redistributed in a more equitable manner. That's why you always hear that term equity. And this would be for the common good and bring about utopia. That's why you're also hearing for the common good as well. In order to bring about utopia, the Marxists believe that society needs to completely change, and to achieve this, you first need to destroy the 5 key pillars of society, which are religion, family, education, media, and law and order. So this is an extract actually from the Communist Manifesto, where it talks about the need to abolish the family. They talk about, and what they actually believe is that the family structure was created by the really wealthy people back in the day in order to be able to pass property down. That's what they thought the nuclear family was created for. And they think that if you destroy the family, people won't have a need to have property because you have nobody to pass it to. And then everybody can own everything communally. It'll be all so fair, and we'll all live in utopia. That's actually what they believe. So that's one of the reasons they want to destroy the family, the nuclear family, and they also want to destroy private property rights. So Marxists believe that the nuclear family is the ultimate symbol of oppression, with husbands oppressing their wives, parents oppressing their children, and that the nuclear family serves the interests of capitalism as they produce the next generation of workers to be exploited. Marxists believe that the nuclear family rose to prominence because of capitalism, and that we moved from primitive communism to capitalism through the establishment of family norms, such as private ownership of property and inheritance. And this was done primarily through the oppression of women and children. I'm so oppressed I am. During primitive communism, there was no private property and thus no social classes or private family units. Property and resources were owned collectively, and this is the ultimate goal of Marxism, to revert back to this way of life. So they think that if they can abolish the family, abolish the nuclear family, you'll have nobody to hand property down to, and then there's no reason to have property. Then we all own the property communally, and then we all live in utopia.
If you own nothing, you'll be happy.
That's literally it. You will own nothing and you will be happy. And if you're not happy, we really don't care. So that's the first potential consequence. The second one is taxation, social welfare, succession, guardianship and family law. So you can see this extract below from the Bill Digest, where it's talking about if you're part of a marital family, that there are certain areas of law that affect you, and they're saying it's taxation, social welfare, guardianship, succession, family law. So because the government refuses to define what other durable relationship means, an ex-partner that you had an obscure relationship with sometime in the past may very well have a legal claim over your property, both in life and in death, in the same way that a husband or a wife would. So Senator Michael McDowell actually raised this recently, and he was saying it in relation particularly to like farms and that too, that people who you think, you know, you had an obscure relationship with, that you didn't think had any legal rights over your property, may actually have rights over your property if this is passed through. And then finally, immigration. So serious concerns have been raised by numerous TDs and senators regarding the very real impact a yes vote could have on immigration rights, and specifically reunification rights. And the most recent poll on Irish attitudes towards immigration found that 59% favoured a more closed policy in immigration, while only 16% favoured a more open policy. And in light of that and similar results, if this legislation would have any potential impact on immigration or reunification rights, that really should be put to the people so they know what they're voting for. So because the government refused to define what other durable relationship means, the term will certainly be exploited to facilitate unlimited numbers of economic migrants entering the country under family reunification programmes at the expense of the Irish people.